Be ready for the dictation. Start. After having considered the aforesaid ratio and also the reasons which have been assigned by the Additional Sessions Judge, District Haridwar, this court is of the view that the revision deserves to be allowed and the same is consequently allowed. The order dated 21st June 2018 passed by the learned Additional Sessions Judge, District Haridwar in Sessions Trial Number 228 of 2016, State vs. Chandarpal and others is quashed. The matter is remitted back to the Additional Sessions Judge, District Haridwar, to reconsider the application in the light of ratio as propounded by the Honorable Apex Court's judgment in Rajesh case. After the order of the High Court dated 11th July 2019 in the criminal revision, learned session judge again considered the application under Section 319 Criminal Procedure Code. Learned session judge referring to the observations made by the High Court in paragraph 5 as well as the judgment of this court in Rajesh and others versus State of Haryana, Supra, allowed the application and summoned the appellants by order dated 17th August 2019. The trial court issued a bailable warrant against the appellants on 5th September 2019 and after bailable warrant being served when they did not appear on 18th September 2019, non-bailable warrant was issued to the appellants and a notice under Section 446 Criminal Procedure Code was issued as to why the amount of sureties being not realized from two sureties Arun Kumar and Chandrapal. The appellants filed criminal revision before the High Court against the order dated 17th August 2019 of the Additional Session Judge summoning them. The High Court dismissed the revision noticing a subsequent order dated 18th September 2019 by which notice has been issued under Section 446 Criminal Procedure Code. The High Court took the view that the revision was filed on 23rd September 2019 but the order passed by the court on 18th September 2019 has not been brought on record, hence, there is concealment of not placing the order on record. The High Court further observed that since the proceeding in pursuance to allowing the application under Section 319 Criminal Procedure Code has already been initiated, in which the revisionists have already invoked the jurisdiction of the revisional court in which order dated 18th September 2019 has been passed, the revision is to be dismissed. Aggrieved by the order of the High Court dated 27th September 2019, this appeal has been filed. We have heard the learned counsel for the parties and have perused the record. The principles for exercise of power under Section 319 Criminal Procedure Code by Criminal Court are well settled. The Constitution Bench of this court in Hardeep Singh vs. State of Punjab and others has elaborately considered all contours of Section 319 Criminal Procedure Code. This court has held that power under Section 319 Criminal Procedure Code is a discretionary and extraordinary power which has to be exercised sparingly. This court further held that the test that has to be applied is one which is more than prima facie case as exercised at the time of framing of charge, but short of satisfaction to an extent that the evidence, if goes unrebutted, would lead to conviction. Power under Section 319 Criminal Procedure Code is a discretionary and an extraordinary power. It is to be exercised sparingly and only in those cases where the circumstances of the case so warrant. It is not to be exercised because the magistrate or the sessions judge is of the opinion that some other person may also be guilty of committing that offense. Only where strong and cogent evidence occurs against a person from the evidence laid before the court that such power should be exercised, and not in a casual and cavalier manner.